Hi, Gary Cunha, attorney and counselor at law. Today we're going to talk about traffic tickets in Texas. If you've been cited for a motor vehicle moving violation or similar Class C misdemeanor offense, while most people are familiar with the defensive driving option, whereby you take a defensive driving class and your citation does not go on your record, there are actually lots of different options for you. I am also a Texas prosecutor, and what I like to do is work with people to find the best solution for their situation. So before you go online and search for all sorts of silly, ridiculous requests for discovery and other information that you're probably not going to have any realistic use for, this is what I would suggest instead. First of all, many cities will give you a reply form that will give you a list of several options that you can undertake. Review that list and see if any of those options seem to be best for you. If you don't like that, you can always plead not guilty and ask for a pretrial conference with the city's prosecutor. Many of the prosecutors, like myself, are going to be very reasonable and try to work with you rather than be very harsh. First of all, if we discover that there is a mistake with the citation, or perhaps not clear evidence that a conviction would be had in court, we will dismiss the citation. But even if there is strong evidence of guilt and a likelihood of a conviction at a trial, we are still willing to work with you. If you've missed the deadline to take defensive driving, you can always show up at the pretrial and work out a plea bargain with the prosecutor. For example, deferred, what we call deferred disposition, is a very similar process. Basically, it's kind of an informal probation. If you don't get another violation or any other criminal conviction during your deferral period, then the ticket is dismissed and does not go on your record. There may be different terms and conditions for your deferral depending on the severity of the violation and the age of the offender and so forth. The prosecutor can require you to take a defensive driving class, a drug and alcohol class, an Alive at 25 class, or some other similar class. And for certain drivers, those classes are required. Additionally, prosecutors have a large amount of flexibility to give you a deferral period to allow you time to pay off any special assessments or any other fees that need to be paid. Remember, with video cameras in virtually all police vehicles and many officers wearing what we call body cams, the evidence is usually very strong and conclusive one way or another, and typically that evidence is strong and conclusive towards guilt. For example, oftentimes when police officers are running radar or laser speed enforcement, the video will be running and you will see the traffic flow going, and it will be very obvious when a vehicle speeds past. So in cases such as that, even without radar or laser evidence, there's still a strong likelihood of conviction. If you're going to have trouble paying your fine or need additional time, this is a great opportunity to discuss this with the prosecutor. For example, if you have a $299 fine or special assessment that needs to be paid, many courts will require $50 a month payment. So you can ask for a 6-month or what we call a 180-day deferral period to have enough time to make that payment. Remember that having a pretrial conference with the prosecutor does not waive any of your other rights. So before you get on the internet and start sending in a bunch of documents that you think may or may not be helpful to your case, I would strongly urge you to talk to the prosecutor first. If you run across an unreasonable prosecutor and you're not able to work anything out, you still have your right to trial, you still have your right to discovery. I hope this video has been helpful. If you like it, give it a thumbs up. Appreciate a subscribe, and if you have any questions, feel free to leave comments below. Thank you.